It is 2:14 on a Tuesday afternoon. You are sitting in a law firm conference room on the 43rd floor. The chairs are leather. The water is still. The view is extraordinary. Across the table, your brother, your sister, people you grew up with, people who know your childhood nickname, people who have seen you cry. Their attorneys are billing $950 an hour. Yours is billing $1,100. The number on the document between you is $500 million. Nobody is speaking. And the thing is, 3 months ago, everyone in this room loved each other. How $124 trillion begins to move, and what it finds when it arrives. Here is a number that does not feel real. $124 trillion. That is the projected value of assets changing hands in the United States between now and 2045. Baby boomers, the silent generation. Decades of accumulated real estate, equity, business ownership, trust structures, all of it beginning to move. Cerulli Associates revised their estimate upward in 2024. The original projection was $84 trillion. Then markets climbed. Wealth concentrated further. Older households, as of 2023, now control 61% of national wealth. 3 years earlier, that number was 54%. The transfer is accelerating. And into this acceleration, there is one quiet, stubborn fact that nobody talks about at the estate planning conference or the family dinner. Nearly 2/3 of Americans have no will, no trust, no directive, no letter of instruction, nothing that says in writing who gets what and why. According to Caring.com's 2024 survey, 2/3. So you have $124 trillion preparing to move, and the majority of the people holding it have not written down their intentions. I have watched this before. I have watched families spend 30 years building something, a business, a portfolio, a legacy, and then spend nothing, not a single afternoon, designing how it transfers. The result is not chaos. Chaos would be easier. The result is a conference room on the 43rd floor at $950 an hour per sibling. Why inheritance stops being about money and starts being about something older and harder to name. You need to understand something before the first document is signed. The money is not what this is about. On paper, it is about the money. The number is there. The attorneys are there. The argument is about valuation, about the terms of the trust, about what your father intended when he wrote the clause that nobody can agree on now that he is not here to explain it. On paper, it is financial. In practice, it is a referendum on who was loved more. Estateplanning.com described it this way. What appears to be greed and pettiness are really symptoms of survivors' struggle to feel loved and important. And there is something in that sentence that stops being abstract the moment you are in the room. Your brother got the company. You got the real estate. Your sister got the investment account. The values are close, within 4%. But she got the investment account, and you know, without anyone saying it, that the investment account was what your father talked about at dinner. The one he built himself. The one he was proud of. She got the thing he was proud of. Others may interpret how much they inherit as how much they are loved. That is not a metaphor. That is a mechanism. And once that mechanism activates, the argument is no longer about percentages. It is about every Christmas where he praised her more. Every phone call you thought lasted longer for him than for you. Every time the approval felt uneven. The money is just the scoreboard. Nearly 40% of people have had a disagreement with a sibling over inheritance. Fair Will, the specialist will writing service, found this in a survey of people who had been through the process. Not a dispute, not a legal filing, a disagreement. The quiet version, before the attorneys. The 40% is a floor, not a ceiling. What a $1 billion lawsuit looks like from inside a family that had everything. In 2002, a sister and brother walked into a courthouse. Their names were Liesl and Matthew Pritzker. Their grandfather was Jay Pritzker. Their family owned the Hyatt Hotels chain, among other things. They were not struggling. The Pritzker name was one of the most recognizable in American business. They filed suit against their own father, Robert Pritzker, and other relatives. The claim? Approximately $1 billion had been unlawfully taken from their trust funds. $1 billion. Not missing by accident, not lost in a bad investment. Taken. That was the allegation. The case lasted 3 years. In 2005 it settled. Liesl received $500 million. Matthew received $500 million. Both of them relinquished all further claims on family assets. The remaining Pritzker fortune was divided among 11 other relatives. Let that sit for a moment. $500 million per person as a settlement. Not a victory, a settlement. The number they accepted to stop arguing, and when it was over, the family was divided, not just legally. The architecture of a dynasty that had operated as a single entity for decades, fractured, restructured, parcelled into smaller pieces with clean legal borders between them. The Pritzkers are not an anomaly. They are a case study in what happens when the structure beneath a family fortune is not as solid as the fortune itself. The Koch family ran a parallel experiment. Fred Koch had 4 sons: Charles, David, William, Frederick. In 1983, William and Frederick sold their shares in Koch Industries to Charles and David for what was reported to be more than $700 million. They felt shortchanged, so they sued. The lawsuit lasted 18 years. 18 years of litigation, of depositions, of legal filings, of attorneys billing time in increments of 6 minutes. The amount contested was $2.3 billion. For years, the brothers reportedly communicated only through lawyers. They made efforts, public efforts, to discredit one another. The case settled in 2001 for an undisclosed amount. 18 years. 4 sons of the same father. 1 family name. 1 industrial empire. And 18 years of communicating only through lawyers. I have seen this pattern before. Not at this scale. But the pattern is the same at $5 million as it is at $5 billion. On paper, it is a dispute over valuation. In practice, it is 2 brothers who cannot be in the same room. The math continues. The family does not. From Australia to Prince's estate, why complexity is the enemy, not the protection. Gina Rinehart is the richest person in Australia. Her net worth is approximately $38 billion, built on iron ore mining, inherited and expanded from her father, Lang Hancock's foundation. In 2023, 2 of her children, John Hancock, 47, and Bianca Rinehart, 46, squared off against their own mother in what the Australian press described as one of the most bitter family showdowns in the country's legal history. The claim that their grandfather had left them stakes in an iron ore mining complex through a family trust, that their mother owed them billions, that she had taken what was meant for them. The case reached the Supreme Court of Western Australia. In 2025, Bianca, who had been appointed trustee after a 4-year legal battle, was reportedly using that position to obtain documents to prove her mother had engaged in misconduct in the fund. A mother, her children, a trust, a mining complex worth billions, and in 2025 they are still in court. Now consider Prince. He died in April 2016. He was 57. He left behind a catalogue of music that is nearly impossible to value, multiple properties, decades of intellectual property rights. He left no will. A judge ruled that his 6 siblings should inherit. But dozens of people came forward, claiming to be his wife, his children, his relatives. The disputes over valuation, what the estate was actually worth, compounded the disputes over who was entitled to it. In 2022, a court ruled the estate was worth $156 million. The legal proceedings had lasted 6 years, and as of July 2024, Prince Legacy LLC was still the subject of active litigation. Members of his family sought to oust 2 executives from estate management. A court ruled against them. The dispute continued. Then there is Howard Hughes. Died in 1976. No will. A drawn-out legal battle involving individuals claiming to be heirs, some of whom produced fraudulent wills. Ultimately, 22 distant relatives divided the estate. The legal battle lasted over a decade. Pablo Picasso died in 1973. An estate of more than 45,000 works of art, multiple properties, gold bonds, $4 million in cash. No will. The father of 4 children by 3 different women, some out of wedlock, some of whom could not legally be recognized as beneficiaries. There is a pattern here. The larger the estate, the more complex the asset structure, the greater the absence of clear documentation, the longer it takes to resolve. And while it is resolving, the attorneys are billing. The assets are frozen or depleted. The relationships are being destroyed in real time, in courtrooms, in depositions, in filings that become public record. Brooke Astor, New York socialite, philanthropist, had her son Anthony Marshall convicted of grand larceny after her grandson Philip accused him of mismanaging her finances, selling her artwork, and mistreating her in her final years. A grandmother, a son, a grandson, a criminal conviction. On paper, these are inheritance disputes. In practice, they are families consuming themselves. What 58% of families discover too late, and what the other 42% did differently. Without a proper estate plan, 58% of families have experienced feuds and had assets fall under court control. That figure comes from research into estate planning outcomes. It means more than half of families navigating large asset transfers without a clear structure end up in conflict. Legal conflict. The kind that costs tens of thousands of dollars before the first day of trial. 3 million probate cases in the United States annually. That is the estimated volume. And 72% of Americans don't feel confident in their ability to manage a large financial windfall. Citizens Financial Group surveyed 1,500 adults, nearly 3 in 4. Here is what the 42% who avoid catastrophic conflict tend to have in common. Not more love, not better relationships, not fewer old wounds. Structure, documentation, and, most importantly, a conversation that happened before the funeral. Transparency around the rationale behind inheritance decisions can prevent misunderstandings. That is how one wealth advisor put it in a piece from City Wealth magazine in 2025. Understated, clinical. What it means in practice. The parent who sat down and explained in writing why the eldest got the business and the youngest got the trust, rather than leaving that explanation to a document signed in the presence of attorneys at a conference table on the 43rd floor. The Williams Group, a family wealth consulting firm, has cited breakdown of trust and communication within a family as the top reason wealth doesn't last across generations. Not bad investments, not market timing, not taxes. Trust. Communication. Today's families face a timeline compression that previous generations never navigated. James Burns Law described it this way in 2025. When the family patriarch lives to 95, his heirs might be in their 70s before inheriting. 70-year-olds with competing financial needs, competing timelines, competing ideas about what the money represents, waiting for a resolution that arrives too late to redirect their lives. The December 2023 Goldman family case. Jane Goldman took over as head of the family company after her father. Other family members sued, claiming a power grab of the family fortune. The Safra banking dynasty. Joseph Safra died in 2020. The succession planning was unclear. Massive inheritance disputes followed. The Vanderbilts. Cornelius built one of America's most powerful fortunes from railroads and shipping. After his death, the infighting began. Later generations sued each other over inheritance and property. The dynasty fractured. These are not cautionary tales. They are engineering reports. What failed was not character. What failed was structure. The architecture was not built. And when it was not built, the family filled the empty space with itself. What you should take from this. Here is what the scoreboard actually reads. You did not become your sibling's enemy because you are greedy. You did not become your sibling's enemy because they are greedy. You became enemies because someone died. And in the absence of their voice, in the vacuum of an explanation that now can never be given, the money became the only language left. It said, who was loved, who was trusted, who was chosen. The attorneys showed up because there was no other interpreter. The research on this is quiet but consistent. Most inheritance conflicts erupt between members of the same generation. Sibling rivalry, not parent-child tension. The people who shared a childhood, a name, a table at Christmas dinner. The people who remember the same house. I have watched this. Not 11 times, more than 11 times. And the thing that stays with me, the thing I cannot make mechanical enough to lose its weight, is that in almost every case, the conflict was not about what the estate left. It was about what the estate failed to say. A number can be divided. A portfolio can be liquidated and split. Real estate can be appraised and allocated. What cannot be divided is the question. Did they love us equally? And if no one wrote down the answer, the children spend the rest of the estate finding out. You will not win that case. Nobody wins that case. The attorneys will bill until the number is smaller. The relationships will be restructured into something with legal borders. You will see each other at funerals, if then. The ledger always balances. The question is what currency it uses to close. The architecture doesn't wait for you to be ready. Somewhere tonight, a woman is opening a folder she has never opened before. She is 63 years old. Her father passed 8 weeks ago. The folder contains the will, a document that was written 17 years earlier, before the second business, before the divorce, before the grandchildren were born. It does not reflect what he intended. It reflects what he intended in 2007. Her brother is on a flight home. Her sister is already calling an attorney. She is sitting at a kitchen table with a cup of tea that has gone cold. She thinks this is about the estate. She will learn it was about every moment in her childhood where she wondered if she was the favourite. The $124 trillion is moving. It is moving right now, tonight, while the cup goes cold and the flight lands and the attorney picks up the phone. Most of it is moving without a plan, without a letter, without a conversation that someone decided to have before it was too late to have it. The architecture doesn't care who occupies it. It only requires that someone builds it, or it will build itself, and you will not like what it builds.